Thank you very much, Knut, for the introduction. I'm not really a speaker. I think Tamar is more our speaker. This is going to be a discussion, a question and answer between the two of us. And if we have time at the end, perhaps some of you will have questions for Tamar as well. So Tamar, I've only known you for 20 years, not 50 years. Long. 20 is not very long at all. We met when you were a fellow at the SEC in the late 1990s. One of my regrets is that I did not have you as a professor when I was at this law school. That's unfortunate. But I do know you long enough to know that you are a person of substance, and so we are going to jump right into the substance. I want to talk a bit about the fiduciary duties and the fiduciary relationship, and let's start with some current events, and maybe we'll get into some other topics if we have time. So I wanted to ask you a little bit about the recent activity on the state level with respect to fiduciary duties, and states such as Nevada, which are now imposing a fiduciary duty on brokers that give advice. That seems like a very interesting development. I'd love to hear your comments about that.
Well, sometimes when things go wrong and there's a lot of conflict, the more conflict there is, the better off we are, because that may lead to a more rational result. What I found is that the arguments that we've had on this subject, and I think Ms. Brosey has a better view of that, first of all, have taken enormous amount of time. And the arguments were about nitty-gritty details, a word, a comma, if I'm not mistaken, something of this sort. Principles were thrown out or didn't even get in. And so the result has been a tremendously long, complicated, detailed rule. Now, what does such a rule do? First of all, it has an attitude that I would like to speak about now, because I believe that it is an important issue. We have two areas of law or of behavior. One is rules. You must use them, you cannot abuse them. The other one is total freedom. And we don't have in between very much area. But there's a British judge many years ago who did say that, and I would like to read it, that between these two areas of absolute law, absolute freedom, there's a third large and important domain in which the rules are neither positive law nor absolute freedom. In that domain, there is no law which absolutely determines our course of action. And yet we feel that we're not free to choose as we want. And this is called the domain of obedience to the unenforceable, not to the enforceable. Lord Moulton then noted, the real greatness of a nation is measured by the extent of this land to obedience of the unenforceable. It measures the extent to which the nation trusts its citizens. Now, I believe that what we have been doing is moving towards the absolute specificity and absolute freedom if it is not written. And as a result of it, not only not written, if it isn't according to the dictionary, not according to meaning, not according to background, but the dictionary. If the dictionary says that it's okay, then I'm free to do whatever there is. And I'm afraid that that is where we are going, and therefore I look to what the states are doing now. They add a mess, there's no doubt about that. They add disagreement, and no doubt about that. But they will also add some measure of this area between federal and state, and maybe show us the way.
Well, let's just probe that a little bit. I mean, why do you think that this is happening now in the States? Is it tied to the DOL rule and let's say, the lack of aggressive implementation of that rule by the DOL? Are they somehow related? Do you see the states stepping in to fill a void, or do you think that those activities are not related to each other?
No, I don't think that it is related to enforcement. On the contrary, when I look at such a rule, I can see that there was a lot of movement towards, okay, let's find out some solution. We don't agree to that, maybe we'll agree to something else. Yes, it shows when you, it shows a long-term relationship and negotiations. What else can you ask for? So the answer is, I think that what the states may have done is simply said, we've had enough. And you don't seem to come to any enforcement, but not, I don't know if, I didn't talk to them, so I don't know whether they disagreed or whether they, what the criticisms is. But the one thing that they did show me a criticism, enough is enough. And therefore, we are going to do it, at least here in our state.
And you said a few minutes ago that what you think the states are doing in some respects is a bit of a mess, right? Because we have a number of states and each state can come up with its own standard. As we know, the states will come under criticism from members of the industry for having a different standard in 50 states, or at least any number of states. Where do you see that going in the future?
Well, sometimes you need a lot of mess before you clear up. It's not always an easy way. What I see here is those even that object to anything, they want total freedom, they may cause others to say, wait a minute, we can't live like this for any length of time. We want some rules and we want to deal with something else, not with this. We can't fight forever. And so the answer may be that sometimes you need more pain in order to resolve the issue altogether. And it seems that this is more pain because it is pain for those who disagree as well as for those who agree. Because now, I'll say one thing. I remember a time when mutual funds had to abide by the state law with respect to their prospectuses, 50 prospectuses. The answer was, it was tremendously costly, yes? So finally, it came and became a rule on the federal level. And I think this may be the need or the cost in order to bring a final federal level.
So I want to take a bit of a deeper dive into the nature of fiduciary duties, which I know you've written about, and I've found those writings to be very instructive. This is an area which I find of great interest. I hope at least some folks here will also find that of interest. As you know well, some scholars take the view that fiduciary duties are contractual in nature. And of course, we know that there are some ability to contract out of some fiduciary duties. I wonder if you could just take a few minutes and give us your view on that contractual view. I know you disagree with it, but it would be helpful maybe to hear why.
Fiduciary relationships are really power relationships. They're relationships by some people who must trust, not because they want to, but because otherwise they can't use a doctor, they can't use a lawyer, they can't use so many other experts. And they don't want to live in a society in which those experts don't exist. So that is therefore necessary. If you contract out of it and say to the doctor, why don't you experiment in me? Give me this pill, that pill, maybe it will make me either worse or better, and that is. I don't know to what extent a person would say that. I don't know to what extent, but there are some people who are willing, because they feel so sick and so on, to experiment. That is fine. Because they hope that maybe one relationship will, or one pill will give the solution. As far as contracting out, it depends on the power and the ability of the person to evaluate what is giving away. He's giving away protection. And some people, I don't need it, and that's fine. I have no problems with that. I have a problem with some people who sign without understanding exactly what they're giving up and the protection that they're losing. That will be a problem. So to that extent, the contract must be of knowledgeable people.
But where do we draw that line, Tamar? I mean, if we have, for example, what somebody who's defined as a sophisticated investor because they have over a certain amount of money in the bank, that does not necessarily mean that they will understand the details of the duties and obligations that should be imposed upon them, yet they sign and say, yes, this conflict of interest is hereby waived. Should the court step in and say, sorry, we're going to just remove that contract, or is that contract upheld?
Well, maybe I'll go a step backward. I don't think that there should be many such withdrawals to start with. So to that extent, maybe the court should make absolutely sure that the person understood the implication of what that person is signing. If that happens, then those who would like to bask in the warmth of conflict would not suggest to just anyone to sign it. The problem is that when the court says you signed, you put your Hancock and that's fine, that I think is a problem. So let the court do a little bit of work and find out, did these people understand the implication of that waiver?
So would you then recommend a regime where we have two different kinds of fiduciary duties? One, for example, that applies to individual retail investors and another that applies to institutional investors, and we separate the fiduciary duty and say, well, we have two separate regimes?
No. As a matter of fact, fiduciary duties are a slippery slope. There are some people who can fend for themselves in some situations and not in others. And therefore, fiduciary duties are really balancing different power structures or different powers by different people or institutions. So the desire for exactly putting the line is the wrong one. All a court should do, and maybe people too, and then we won't have the courts, is simply say, can they fend for themselves in that particular situation? It means that when I deal with somebody else, I cannot just automatically say, if you are 22, then you can take care of yourself. If you are 25, you can't. I don't think our laws should be designed that way, especially not when you talk about balance of power.
Mm-hmm. It sounds like you want to place a little bit more responsibility on the courts in this area.
No, not necessarily. Maybe on the people themselves, those who want it simple. Yes, sign. The answer is you can't make it simply. If you take the power for yourself and take the power away from the other person, then you must do some homework before that. Doctors do it all the time. Why not advisors?
So I know that you don't subscribe to the contractual view of fiduciary duties. I'm interested to hear, which I think might also be of interest to the lawyers in the room, and I think also to some of the non-lawyers, if fiduciary duties don't fall under the rubric of contract, then where do they fit? Do they fit under the rubric of tort? Do they fit under the rubric of property? Or do they fit under neither, and they have their own area of the law?
Well, first of all, I am not sure that we should be locked into these categories. Life doesn't. There are many machines. This one, for example, I don't know where that one fits. Does it talk to me? Does it talk to them? So this kind of rigidity of classification, I'm not sure, is a healthy one. But I would say if we want to classify, then it is the balance of power category. And what you see now, and one of our colleagues here, yes, Professor Seidman, we have a book now about the Constitution and fiduciary law. Where does that fit? Into a contract, into a tort? It fits into the balance of power. It fits into people who have power over others have duties. They can't extend them to what is unacceptable in our society.
Mm-hmm. So that opens up a very interesting set of questions regarding public fiduciary duties, which I know at least you're knowledgeable about. There are some scholars, some public law scholars, some of whom you know, I think, pretty well, who are looking to fiduciary law to explain the duties and obligations of our civic leaders. There are now books and articles through these public law scholars. Do you think fiduciary duties have application to public life? Is this a fruitful line of research, and what are your views?
I think it is. I think people who have power, there was a time, maybe I should say that, there was a time when children were the property of the parents. Parents could do anything they want with them. And now we have recognized that that is wrong in our society under our values. And the same thing applies, we are the children, maybe of government and so on. The time has come to view not excessive power, but power relationship as a guide or maybe a classification, if you will, of parties, whether they are, there's one more thing that I would add to that. If we begin to be a group of people who distrust each other, we're going to be the poorest country in the world. We won't trust doctors, we won't trust lawyers, we won't trust anything. Now, trust means that I give up the ability to find out precisely what the other person is doing, and the other person is free to do anything that it can benefit the other person at the expense of the other. It's so simple. We have balance of power in so many ways that we accept, and this is the area of fiduciary law.
Mm-hmm. If we could just follow up for a second on this issue of power, I find this very interesting. When you talk about power and fiduciary relationships, I think there is some disagreement among scholars on what exactly that means. So, as I think you know, there are some scholars who argue that power really means some sort of discretionary authority over the assets and affairs of the principal. So, for example, a broker or advisor who has discretion, as it's defined in the law, that's a given, that's one type of power. Is this what you mean by power, or is power something different and short of that kind of clear discretion as we understand it?
Well, I'm willing to say that clear discretion moves with our changes in life, with our changes in the economy, in technology, in a variety of things that we never thought existed or would exist. So I would say that power cannot be defined today for the future. So what is power? Power is this inability of one party to protect itself against undesirable, and I'm being very general, yes, undesirable results that the other can impose upon it. And you can see the movement even today. So maybe I did not answer your question.
Right. So the question is, should we, when we think about power, should we be defining it in such a way that it is true discretionary authority over your assets, over your affairs? Many advisors, as you know, don't have discretion over
Right.
assets, but I think we would both agree that they should still be considered and are considered fiduciaries. Yet they don't have the kind of power that one might define as real power under the definitions, the legal definitions of discretionary power.
Unfortunately, yes, we can define without defining the lines that we draw. A broker is a fiduciary with respect to the money that the broker receives, controls, and trades on. Is an agent, obviously, yes? So agency can range from a very, very limited one to a very broad one. It's not defined, but we can more or less evaluate it. And that's the truth about every other thing. This desire to say, it's the dictionary again. I'm falling into that dictionary. The desire to say exactly what it is, and then I'm free. That's wrong. We shouldn't live like that. As a matter of fact, most of us don't live like that.
So one more just follow-up question that comes as a result of what you said on public law and public fiduciary duties. If we do look to fiduciary relationships as a model, and as I say, there are a number of scholars
Right.
doing that today, is there any risk in applying fiduciary duties too broadly so that the concept becomes diluted and becomes less meaningful if we talk about government officials as fiduciaries and parents as fiduciaries, and like our colleague wrote, friends as fiduciaries? It could be one group after another. Is there a risk in going too broad?
Of course there is. There's a risk of exaggeration in everything we do, in food, in sleep, in everything. I don't see the precision to be, I'll tell you where the precision comes from, because the assumption is that if it is not precisely prohibited, I'm free to do anything. And that is where the wrong comes. We must live with imprecision, and we do live with imprecision. So I don't see that as a risk. On the contrary, I see that as an acceptance.
So I know that this is not your favorite topic, but I want to speak a little bit about your background. Sorry, I know that you asked me.
That'll be short.
Sorry. So we know, most people in this room know you came from another country and another culture. And I wonder if you could share with us how that background might have affected your views. I'm interested in your views on fiduciary duties, but of course you're welcome to share your views on other areas also. Did that somehow make a difference?
Yes, it did, I think. I came from a country, as a matter of fact, from a country that began as, when I was born, was a very small community. It lived in danger. The community was a mishmash of so many languages, food, the way you behave, and so on, cultures, but was very small, and you had to interact if you wanted to live and not be attacked. So what was the glue was really danger, and the danger was real. It wasn't kind of in the mind. So what you learned is to accept, first of all, what you can accept, to be much more sensitive to the culture of others, yes? There are, and I gave that example, but if you ask a person from a Muslim, how is your wife? He would say that's none of your business. But if you don't ask a German person, how is your wife? He would say, what kind of a boor are you? Not to ask, it's the right way to do. So it starts with these very small things, but it can continue to life and death. So you get used to be sensitive and to accept up to a certain point how others behave, yes? And what they expect of you. Coming to another country is then easier because you don't accept, first of all, you are not rigid. You eat a lot of different foods, a lot of things. And second, before you decide whether you want to be part of that group or not, you can wait and find out whether it's possible within your principles. And that's really what coming from this small country and varied country helped me adjust without fully adjusting. I did not become a fully American, but neither I feel very, not only comfortable, but thankful. I think it's a generous country. It gave me an opportunity. That's all I could ask for.
And so you began writing about fiduciary duties a long time ago. 35 years ago were your first articles. There were
Right.
very few people at that time writing on fiduciary duties. Now it is very much its own discipline. People teach fiduciary law in law schools. There will be a case book, another case book on fiduciary law. I wonder if you could comment on those beginnings, back when you wrote the first piece in the California Law Review. What drew you to the topic? How did you know at the time that this would be so important? Or maybe it was just dumb luck.
First of all, I didn't know. Nobody kind of whispered in my ear this possibility. I deeply believed in that. That, yes. And neither, it depends why you write. Yes, I wrote because I believed in it, not because I think that I'll have rewards afterwards, like sitting here. I never even thought of the possibility. So it is sometimes, and that's what happens to me, there's a drive to write. And I guess I got it because of my family. Yes, my father, grandfather, and I found out later that many other people in my family were writers. And so that was the way I expressed myself. But if I believed in something, I would write it not in order to find out that it will. Well, there's one more thing. I don't mind if people disagree with me. And they did, yes? Sometimes people who were very powerful, a judge and so on, don't understand. Well, I do. I believe in that. Sorry. There's nothing wrong with that. I think that this is one of the things that is more American, that people don't argue. It's not the right way. You have to agree. Well, coming from Israel, you argue all the time. You argue with people you love. You argue. And you learn this way, by the way. That's a way of learning. I disagree. because of that, because of that. So the disagreement is not devastating. So you disagree, okay, I still believe this is right.
And I just have a few last questions about this institute itself. So we won't embarrass Knut too much, but would you mind sharing with us how you first got involved in the institute and what drew you to this organization? There are a lot of demands on your time. Why is it that you took an interest in this institute?
I didn't go to this institute. Knut came to me. That was it. And he talked about it. And there was one more person, and that is the head of Vanguard, John. He also, I met him and we talked about it. But it just came, I don't know, but it just came. I want to tell something. Sometimes I just sit, I don't go. But if people know that I could help or they come. And I found that people come. And I very rarely say no because I'm very interested. And that is what happened in this case. But I'll add one more thing if you'll allow me. You allow me? Okay. Last year, I suddenly received a call or message from the chairman, no, he was the president of Mitsubishi Bank. It's a large Japanese bank. And I found out that they translated the book that I wrote on fiduciary law to Japanese. But then afterwards, I found out that they have established near the main quarter a trust museum. And what they wanted is for me to go to when they open it and give the opening speech. And I want to tell you, I was flabbergasted. The man came to my home to thank me for that book. I tell you that because I feel a high even telling you that now. I went to Japan and we did open, he spoke, I spoke, and the other people, and he said, I'm going to introduce this kind of fiduciary culture, even if it takes me all my life and whatever he talked about. So that gives me life. But did I know the man, or did I have any relationship, or I gave him nothing? I didn't know any of that. So I think sometimes you have to wait 50 years. That's okay. That's okay.
So we have a little bit of time left. Those are my questions for you, Tamar. I know that you have a lot of energy. So if there are other questions, as I say, this is an informal discussion. We wanted to do it informally, but if any of you have other questions or you want to follow up with topics, I know Tamar is that right? You're available to?
Of course.
Yeah, to answer some.
I'm curious.
Yes.
Obviously, transparency is, first of all, valuable only to those who can read it and evaluate it. So if I have all this transparency, reams of paper with details, and I don't have either the time nor the knowledge, then it doesn't help. So part of it is transparency, but part of it is I don't do it. The powerful person should say, we don't do it here. It's not our thing. And the assumption that if I didn't write it down, I can do it. The assumption that if you don't push back, I can do it. That has to change. There are things that people have to feel, I can, of course, but I never would. It never occurs to me to do it. So transparency gives the other person power, but only if he has it, if he understands it, if he can use it. May I say something? I admit something now. It was a few years ago, quite a few years ago. I wrote a little parable, and in that parable, teachers one teacher decided that he's going to give the highest grade to the person who will pay him most. And the other teachers thought that was also a very good idea. And so the entire faculty charged, and according to how much they paid, they gave yes, that became the way to do things. However, when that happened, the employers began to find out that grades don't mean quality. And so they began to discount the grades and create some other measure of quality, and were very dissatisfied with the result. And so the schools slowly and faculty slowly came back to what was before, and that's grading according to quality and not according to the money. However, and that's the result, it did not reach the same result as it was before, because the memory of this kind of evaluation stayed with the employer for quite a while, until the older people said, I remembered, and they were gone, and the new ones didn't. Then it takes time then when you do a thing like that. I don't know if I answered your question exactly, but I think that values are the basis of behavior. And therefore, I don't think, did I answer your question?
He's asking if when one person has substantial expertise
okay.
over another person,
Okay.
There's disparities of information and disparities of knowledge. Does that also translate into the power dynamic?
Yes, of course. Yes. And as a matter of fact, that is the source also of fiduciary duties of the powerful person, because otherwise others will not go if they will not. So that's my parable. Yes?
The power to act, i.e. discretion, right? It's the power to think.
Yeah. The more knowledgeable you are, the more power you have. For those who don't.
Professor.
Right, you talk a lot about the substance of a fiduciary duty, particularly with the DOL rule now injecting that into the broker-dealer world, where it will be arbitrated by arbitrators and more frequently by non-lawyers who know experience in the financial services industry. What is the future of fiduciary duty if we have all of the litigation of what it means in unwritten decisions made by experts?
I would think it depends on how the non-experts will behave and what rules they will put for themselves. Yes, there will be some rules. Yes, people look at others, and if it works for them, they will try it themselves, and so on. So you will create a system of arbitration. If something then comes out that is very different, people are going to ask, yes, then I won't go to you, I'll go to you. So the answer is, I think in some respects, it will be very similar to the court system.
Yeah.
Back in January, Michael Kitces had written a column that talked about the difference between duty of loyalty and duty of care, and suggested that advisors, at least in January, as the rule was written back then, would be able to fulfill the first part, act in the client's best interest, but may not be able to act with prudence, and that class action lawsuits might result because they were unable to fulfill the second part of the duty. Thoughts?
And I'll clarify one point. His point was that the typical broker didn't necessarily have the expertise to know what was in the best interest of the customer.
The expertise, the training.
Well, that is very easy. If that is the answer, then I have an answer. All he has to do is ask himself, would he like to be treated that way? And that will solve the problem.
I use
I think we need both, of course. But the one thing we have to work on, and I think that is not to feel that I'm absolutely free unless I'm told by the dictionary that I can't do it. Freedom is not, has a price, and the price is self-regulation or self-limitation. So the answer is, when you have that kind of an idea, then you look to the dictionary, you find I'll give you an example. When you look at what happened to, what's the name of the bank that, the open accounts, yes?
Wells Fargo.
Okay, Wells Fargo. You see, I don't like them that much. I forgot the name. But the point is that literally, they opened a new account. Where's the liability? Not literally. It's a different story. When they meant new customer, not a new account. Go to the library, and you find they did the right thing, but that's wrong. That's what they meant. So what you have, if I understood you correctly, you have an organization, a group of people that has to make the decision, and some of them are really advocates of the other party. The question is really whether the two groups, the one that takes care of the interests of the institution and the other that takes care of the organization, can they work together? Do they have any basis together? Or do they say, I will either you eat me alive or I'll eat you alive? The question is, how do they want to solve the problem or do they want to win? And if they want to win, it won't work. If they want to solve the problem and say, how can we maximize for both parties rather than for one, then they will win. I think that's the tendency.
So if you could all join me in thanking Tamar for answering our questions.